While Preeti is just fixing on the technical technology side and presenting her PPTs, I just want to briefly introduce you all to the wonderful instructor this evening, Miss Preeti Tyagi. Miss Preeti is a registered Indian patent attorney. She holds a bachelor's degree in biomedical engineering and law. She is also a registered Indian patent agent, enrolled with the Delhi Bar Council, and she comes with like a rich, vast experience of about 16 years of drafting, filing, prosecutions across jurisdictions, uh, USPTO, European Patent Office, etc. And with emphasis on biotechnology, the areas that she works on primarily include biotechnology, medical devices, image processing, bioinstrumentation, nanotechnology, and the like. She has substantial exposure in handling contentious matters, and she works closely with a lot of international clients and helps them manage their patent portfolio. And apart from representing these clients during prosecutions and oral hearings, she also assists them in prosecution of foreign patent also. And she provides technical support during patent litigations and opposition. She has handled various patent analytics and search related projects. We had quite a lot of interesting discussion around the patent search aspect, and invalidity search, freedom to operate search, and all of these. And she's been a regular speaker at various conferences and seminars, actively publishes articles on various subjects related to patents. And we really look forward to reading some of your articles also, Ms. Preeti, as part of the whole process. Do share with us some of your as well.
Thank you, ma'am, for such a lovely introduction.
Welcome to the session. Welcome to the session.
So, just confirm whether this PPT is now visible or
it's visible now.
Visible
Yes.
now. Okay, so we can start now.
Yes, please.
So, the patent, as the attendees maybe you may have heard in the previous presentations, it's about the invention, something that you obtain the statutory right for an invention and for a limited period. That is, for Indian context, we can say for 20 years from the filing date. And in return, the inventors have to give the full disclosure of their invention in a particular format, subheadings, headings, and it is a positive right for the inventors and a negative right for the others not to make, use, or sell this invention for their purpose. Only the applicant has the right to do these activities. So this is just the overall. Then territorial rights, wherever you will file a patent, only in that country, in that territorial region, you will have the protection for your invention. That is why if a invention is very commercial in nature, so you need to file the patent in those countries wherever you have the commercial interest for that invention. And the statutory rights, the rules, the patent act of that particular country would prevail in that purpose. So, about the examination of an application in the Indian context, you need to first file a request for your examination of the application. So if the inventor or the applicant misses the opportunity that they do not file the request for examination, the primary step is that you are filing a patent invention, whether complete or a provisional. The second step is that you need to file a request for examination. That means that you need your application for the patent to be examined by the patent office. And that is having a deadline of 48 months from the priority date, from the first date. If you miss this date, then the application would be automatically abandoned, set to be abandoned. So this is very application is examined only on request for examination. If somebody misses the filing of this request, the application would not be examined. The patent application for that invention, it would not proceed further. So this is a very critical deadline, 48 months from the priority date, or if it is first patent filing of that invention, then the date of filing of that particular invention. Now the whole procedure is that once you file the examination, there would be a first examination report which would be issued by the patent office. Now, once the inventors or the applicant they receive the first examination report, then the deadline starts from that issuing date of FER, that within 6 months you have to file a reply. That means that first examination report would be having certain kind of objections. Certain kind of objections means that they would be like, this is not novel, this seems to be obvious in view of some of the prior documents, some of the prior inventions, or there may be the set of objections that these kind of inventions are not patentable. Although they are new, although they are inventive, but they are falling under the criteria of that they cannot be patented by the Indian Patent Office. Or there can be objections that there are the formal requirements which have not been fulfilled. Some legal requirements have not been fulfilled. Or there can be objections certain type that the invention has not been disclosed, has not been explained in a certain manner. It is not sufficiently disclosed. There seems to be lacking of best example of the invention, how it can be performed, what are the best examples. So these are the certain kinds of objection which the applicant would receive once you get the first examination report. So the deadlines which are very critical are that you have 6 months, normal 6 months to reply back, and it is the uh, it is preferred mode and it is set mode that you file a complete response. It should not be partial, that half of the response you file now and after 2-3 months you file the rest of the objection. It should be one way, certain way, and complete reply to all the objection. Then there would be more chances of having the advanced prosecution or the faster way of having a grant of the patent application. In any case, if there are some delay, that there are some objections and need to prove with some extra data, with some extra technical experiments you need to generate, or some legal requirement is there, some signatures or executions need to be filed, and you need some extra time, additional time for fulfilling that requirement, then there can be only once you can make a request for the extension of time, but that you can choose. It can be for 1 month, but only once one request can be filed, and at that time you need to be very sure whether you need 1 month extension, 2 month extension, or a 3 month extension. So the maximum time would be then normal time of 6 months, and extendable maximum time is 3 months. 6 plus 3 months is the maximum time that you can get. And this extended time, there you need to file the official fee, which is per month basis. So 6 months, it is without any fees. But if you need the extra time, then monthly basis, 1 month is this, 2 month is this, third month is this. So, but the request can be filed only once. This is for the FER. Now, what is the next stage? Next stage is, suppose you file the response to the FER, but the examiner or the controller, they are not satisfied. So you will again receive a next office action. And this second office action is called hearing. This is the hearing notice. Now this hearing notice, there is an opportunity that your agent or the applicant would be given a certain time, a hearing date, where to verbally discuss all the objections. So it normally, generally, we receive 30 minutes of that slot on a particular date. And normally, if there is substantive objection, very lengthy objections are there, then there would be 1 month time. If they're minor objection, there can be 10 days time or 15 days time. So one is FER and one is the hearing notice. Hearing notice you can generally take as the final stage. So FER is the first stage and hearing notice or the hearing is the final stage, second stage of the examination. Now, 1 to 3 months is the extended time and 6 months is the normal time. Now, this is the example of the FER, how it looks. So here it is the summary report. You can see here novelty is there, whether claim number 1 to 10, yes or no column would be fulfilled here. Inventive step for inventive step for the claims 1 or 2, 10 claims or industrial applicability. This is the one set. Novelty and inventive step are always with respect to some prior art, with respect to some prior patents of US, Europe, of India, or some publication, research publication. So whatever is available in the public. So based on that, you can have the objections of novelty, that it is not novel, which means it is objective type. Novel is the objective type, one-to-one comparison. Inventive step, it is also with respect to prior art, but it is subjective analysis. It is not one-to-one. It is, if I read 2 or 3 documents of prior art publication, I can arrive by combining them to a certain invention. So that is the inventive step. Industrial applicability, that this invention can be produced, can be reproduced in an industry. So if you have filed or if you come up with an invention which cannot be industrially reproducible at a later stage, so this objection would come that it is not industrial applicable. Now, non-patentability, section 3, it is very important clause. And here comes section 3A, B, C, D, E, F, G, K, up to O and P and 3A, section 3. We will discuss this section 3 in very much detail because it is very important. Many of the inventions which cross the barrier of novelty, that they are very new invention, which cross the barrier of inventive step, that they cannot become arrived by combining any kind of prior art, but they struck with the non-patentability clause, section 3. Conciseness and scope, these are about when the claims are very important part. At the last page, you will find in every patent, whether it is US patent or EP patent or Indian patent or Japanese, a list of the claim number 1, 2, 3, 4, 5, 6. So those features, those claims, these are the actual rights, the right of the invention. Apart from that whole specification, it is just the explanation of that invention. But your actual right comes with the claims. That is your territory, your boundary of your invention where you have the exclusive rights. So claims are examined, whether they are the scope of that claims, the wordings of the claims, they are clear or not, where their clarity is there, definitiveness of the wordings are there. So, for example, this is just an example where the claim non-patentability clause, it has been on section D, E, and I. This is how the FER looks. This for the clarity and conciseness, that these are the terms used in the claims, that these terms or these features, they are not clear, or these figures, they are not matching, or inconsistent claim features and the specification. There should be very much consistency what the invention is explained in the specification and what you are claiming. Now, these are the formality objections where endorsement by the assignment, this is a proof of right, that inventors are assigning their rights to the applicant, to a company. Many of the companies, they have their patents and inventors who have actually worked on that invention. But while they were having their professional work in their laboratory of that company, while doing that, they have come arrive with an invention. So those inventors, they need to sign, they need to execute a form which is the Form 1 at the Indian Patent Office. So Form 1 has to be signed by all the inventors, that whatever they have come up with that invention, they are assigning their rights to the applicant. That means to their company or to the university where they are working as a professor. So this is the Form 1. It needs to be executed by all the inventors and within a certain time, which is the 6 month. For example, if they have missed or all the inventors have not executed, then this is the formality objection in the examination report which would come, that they have missed it, and then they have to file a petition for that and with the official fee. Then there are the inventions which are filed at the same time in many countries, in India also, in US also, in Europe also, or in other countries. So all the information, what is the stage of those inventions which are filed in other countries, corresponding applications, we need to give the details, their application number, filing date, publication date, whether they are published or whether they are granted, when they are granted. So all these information we need to file, and this form is Form 3. So if you have not filed, or the invention or these particulars have not been given within 6 months, this kind of formality objection would come. Then we need to give the details and we need to file the petition, because we have missed 6 months deadline for that. So in the specification, when we write about an invention, the first thing is title. And now there are the rules, the Patent Rule Act is there, that title should be not be exceeding the 15 words. And the abstract should have the 150 words. And if there are important figure, important drawing is there, then that drawing should be given in the abstract. Field of invention in the specification. So if anything is missing, if we have not been formatted in the certain way, we have not written about the invention in the patent specification, those kind of missed things would come as an objection in the first examination report. So then we need to either give the justification or meet those objections, and if there are some corrections needed, we need to correct those. And if we are correcting those things, we need to file Form 13 and with the official fee. For example, if certain headings, summary of invention, brief description of the drawings, prior art, what are the background inventions, what are the problems which this invention is solving, if these data is not given in the specification when you are describing about your invention, then they have to be rectified when we are filing the reply to the examination report. So all these rectification has to be done, and whenever the controller asks, because you are delaying this thing, so you need to file the petition for those. So best method, if you are providing many methods of performing an invention, what is the best method? What are the best results? And abstract, the wordings limit is there. Drawing, a certain format of drawing is there, that there should be application number there, there should be applicant's name there. So, and there should not be the descriptive matter. Reference numerals for labeling the diagram, they are allowed. But apart from that, all the descriptive matter has to be deleted if they have been filed while originally specification is filed with the patent office. So during when we are filing a response to the examination report, all the drawings format or anything missing with the abstract, with the title, with the specification, these have to be corrected, and necessary fees has to be paid if we have to. So the drafting procedure, drafting is when you are writing about the invention, it is very crucial. Most of the things, if are done in a correct way, the objection would be very much minimized. These kind of objections would not come. And then the advancement of the prosecution, the fast prosecution, early grant of the patent application, it can be achieved if the drafting is proper. So claims each wording. For example, different definitions or different words or different terms for same part of a machine cannot be used. There should be consistency. If we have used a certain term for a certain component throughout the claims, that should be the same term. And for example, claim number 5 or claim number 6 is having a certain term, but there is no base in the previous claims, then the objection would be that there is no antecedent basis for that. If the claims are having the wording such as it is very lighter in weight, it is it is very faster, so those kind of adjectives, they are not allowed. It should not be vague. It should have certain values, some numerical values should be there. How you will ascertain what is the boundary of your invention? So vagueness, ambiguousness, those kind of adjectives or phrases, they are objected. Trademarks, they are not allowed, but that generally, if there are sometimes if we file the claims that trademarks are present, and those feature is very important for the applicant, for the company. So the option for the applicant is now you replace that trademark with some generally used chemical terms, or what is the common name for that particular compound or particular article, so that the trademark should be replaced with a certain other commonly used, generally used term. And that way the objection can be overruled. Or there are some objections. For example, we say that this is the chemical formula where R is 1 to 100, N is 2 to 200, and in the specification no examples are there. There should be examples which should be showing the minimum criteria, minimum limit, mid range, and the maximum limit, so that you can say that all my claim, all my range, this is exemplified. Otherwise, the controller will say, they would object in the FER that you have to limit it. Whatever you have disclosed, the examples which you have disclosed, limit the claim to those examples only. So the first option is that you can argue by providing that on this page number I have provided for this range, for this middle range, I have provided these examples at this page number in this certain paragraph. And then you can also argue that based on these examples, it can be extrapolated. My ranges can be, because it is not possible to provide all the possible example in a single specification. So argument, facts, and if needed in certain cases, additional data can also be submitted. When you are submitting additional data in reply to a objection in FER, this additional data would not be a part of the specification. It would not change the specification. It would only be an argument for the reply which we have filed. And it is more advisable that whenever we are filing any additional data, any additional drawing for strengthening our case, for convincing the controller to meet the objection in the hearing notice or in the examination report, it should be on the affidavit, the notarized affidavit by the inventor or the applicant. So the first kind of objection is on novelty, whether it is a new product or a new process. And very rarely we get the objection of industrial applicability, but in certain cases, this objection also comes. So these are the broad categories of the objections, which you will, when your patent application is examined, these are the broad categories of the objections. Novelty, whether it's novel or not, and certain prior art would be there. Inventive step, whether it is obvious or non-obvious, and certain prior art documents would be there. Industrial application, and section 3 and section 4. Section 3 and 4 are equally important as we say novelty and inventive step. Some of us, you would be aware that by the new word, by the novelty. It means that it's not published in India. Elsewhere also, it is not that you are filing in patent application, Indian patent application. So search would not be restricted to India only. Search would be on the worldwide basis. Whether the same invention has been filed in US, in Europe, in Japan, in South Africa, or elsewhere, or it is the public knowledge, or the public is using that kind of for example, if you are using any ingredient, for example haldi or any medicinal herb which is usually used in India in the kitchen or by the medical practitioner. So when it is public use, prior public use, before filing your invention, then also it would be objected as novelty, that it's not that only published, if it is used also earlier. Technical advancement, when we are comparing that my invention is more efficient, my invention is having certain features, some technical step is there, certain feature is there, some extra component is there, or some in the chemical inventions we have some uh, uh, either the active ingredient is there, or the excipient is providing some additional advantage. So one thing is that you are comparing and able to find out what is the additional thing, what is the differentiating feature. Next step is, by this differentiating feature, can you extrapolate to what is the advantage for this, what is the problem which is solved, which was not possible by the earlier document which the controller has cited. There was some problem which those documents are not able to tackle, but my invention is able to solve that technical problem, or I can avoid those kind of problems, technical problem, or some solving the real life solutions. So these kind of arguments based on these lines, first you find out the distinguishing features, then the benefit of that distinguishing features. So in this way, we are able to overcome the objection on the inventive step. Industrial application means it is very rare objection which comes, but whenever it comes, that it is able to be made, it is able to be used in any kind of industry. This kind of submissions can be made in the reply to the FAR. Now, section 3 is very important because it is very exclusive. If you're filing an invention in India and same invention you are filing the patent application in US, in Europe, or in Japan, novelty and inventive step would come in other countries also. In those the examination reports or the office sections which you will receive from the USPTO or from the European Patent Office, novelty inventive step would be there also. Objections of section 3, these are very exclusive. Most of these, they are only you will find when your Indian patent application would be examined. You will not find those objections. Most of them you will not find in the US applications or the European application, except there are few which you can, for example, section 3A, frivolous or inventions or contrary to well established natural laws. This will be there in other patent offices also, wherever you file the patent applications. Section 3B, morality or public order, for example, which we are up for gambling machine or for house device for breaking any house or destructive machines, these kind of, see, objections would come. But if you can provide any solution which is useful, you can contradict. So based on your arguments, if it is strong, it can go through. Otherwise, these are very strong objections. If you are come up with some biological warfare material or the weapons of mass destruction, whether it is novel or inventive, whatever it may be, it won't be able to, you won't be able to have an easy grant in the patent office, because it would be the cause serious prejudice to the human or animal plant life or to the environment. So the section 3B would be a roadblock for the invention, and it would be very difficult to cross that barrier. Embryonic stem cell, for example, if you come up with the apparatus for the where you are having those stem cell technologies, it would be patentable. So the apparatus or the systems or the machine for that, it would be patentable. But the method or the stem cell itself, it would be very difficult to cross the barrier of this objection. This is also one example of GMOs, genetically modified microorganisms, which do not fall under section 3B and they are patentable. Section 3C, mere any abstract or discovery of any living thing. This also comes with the US application. If you're filing the same invention in the USPTO or in the EPO, this invention would come. Although this section 3 would not be there, their section would be different, but this is also accepted there that this is a certain objection, which they also do not allow. So discovery of any living thing or a non-living substance which is occurring in nature, naturally occurring in nature. So discoveries would not be patentable. Discoveries which are naturally occurring, they would not be patentable. Inventions would be patentable. So how to cross that barrier? If you're able to show that there was some human intervention, that's something you have done with the laboratory, some research you have done. There are some examples of negative examples of not getting the result, then some hit and trial method or sometime with the positive results also. So you need to give uh, a gap that this was naturally occurring, but I have made certain experiments, some intervention, some human intervention has been done so that it is now distinguished from the naturally occurring to a something which is having a human intervention. So that barrier you have to show in your arguments. Only then this section 3C you can able to waive that objection. 3D is very important. It is certain. It is mostly you will find this objection in the pharma, the invention which are falling under pharmaceutical industry. Any medicine is there, any compound is there, any composition is there. There you will get the objection of section 3D that it is not a mere discovery of new form of a non-substance. That means that it is not the mere the salt, ester, what is previously available, what is published, what is patented, only a mere mixture of the isomers or mere pure form. Now we are seeing here the pure form, but if you are able to show with the examples, with the comparison tables, with the graphs, that this pure form is having some advancement, some technical advancement, some technical benefits, and which can solve some problem which is very much suitable for the certain kind of patients. For example, some pure form of a medicine, or it is showing very much efficient results in terms of time, less treatment time, or may able to treat the severe diseases. So even if the pure form is objected here, that only a pure form will not be allowed, but your data, your experimental data would able to solve this problem. That if you are able to show that with even this is only a pure form, but I am able to show the technical advancement, that it is solving a problem. This is the problem with the available form which they are not able to tackle, and the inventors are able to now solve this problem. Data is very important. If it is in the specification at the time of filing, it is most acceptable data. If you are filing the additional data during prosecution, that is after receiving this objection, then it comes under the purview of the controller whether they accept this data or they do not accept this data. Some examiner, most of generally they accept the data as the additional data on affidavit, but it is not binding to them. For example, mere new uses of the neem. Neem is it is also documented decade year traditional knowledge. It is documented now, and it is available with the Indian Patent Office also, and with the other foreign patent offices also. So if you are able just showing a new use, and in the Indian Patent Office, products are patentable. If you're showing a product, if you're able to come up with a product or or the method, they are patentable. But the use, only the use is not patentable. If you're filing a US patent application, use will would be there patentable. But in India, mere use is not patentable. Section 3E, this also comes for the pharmaceutical, for the for the chemical industry inventions, that if it is only a admixture, that you are combining two components, you are combining two ingredients, then the results is only the combination. Like for example, 1 plus 1, it comes only 2. These are examples. For example, you are adding a paracetamol which is known for certain medical effects and the ibuprofen, and you are combining it and giving the same result as one have with these two medicines have taken together, then it would not be able to solve that section 3E barrier which is objected. If you are able to find that there is some third and fourth effect which was not possible, which we are not able to foresee by combining these two components, that third and fourth effect, then it would be able to be patentable. So only a mixture will not be provide that result, and it would be objected. 3F, it comes for the mechanical inventions or the electrical inventions where we have different components which are arranged. So there may be the components, for example, a bucket fitted with a torch. It would be objected that it's not solving any technical problem. That bucket is doing what a bucket is means to do in the prior art, and torch is also doing the same thing. But if there is some real life application, some industrial problem is there where certain kind of this kind of arrangement is needed, and you are able to uh, dig deeper in that problem and show the solution for that, then you might be, otherwise on the surface it would be objected that umbrella with a fan or this only just combination will not go through. If you are able to show that there is some problem in some industry or in some common life, real life problem, and you are able, and with this arrangement, uh, there is some advancement. Method of agriculture or horticulture, what is generally used in the agriculture, what the farmers are doing from many generations. If you are claiming only in the same method, that invention would not be patentable. But if you are adding some step where or some either the method step or some product you are using there where you are able to solve any problem of that agriculture, then it would cross the barrier of section 3H. Otherwise, by seeing the title of the invention, this objection would be raised in the first examination report. So new form, preparation of improved soil. So here you need a much deeper comparison data or uh, some valuable information. What is already there with what they are practicing, and with my invention, what is they are able to achieve. So some data comparison tables are needed. Only then this objection they would be able to overcome. Section 3I, this is very peculiar, that any process which is any giving any medicine or performing the surgery. See, all the products, all the systems, they are patentable. But this is for the procedure, for the process, for the method. For example, how a doctor is performing an operation, how a doctor is performing a surgery by using a certain machine, by using a certain device, by a method of curing, or you are just comparing the results, a lab results, and you are saying that if it is falling in a certain range, the results, the blood results or in any results or diagnostic purpose, then there is certain disease. And if it is not falling under that, then it is showing no disease. Or so those kind of procedure, the method, they would be objected under section 3I. But any machine or any apparatus, if you are providing any surgery apparatus or any diagnostic machine, those are not patentable under section 3I. So basically, by any medical procedure, if the end result is showing diagnosis or treatment of a, and it is connecting to a specific disease, then there are more chances of attracting this kind of objection. So if there is no connection between any disease and your method, or the evaluation of that results and any disease, then there can be certain kind of arguments that you can provide that by following these steps, by following my claim process, there is no pathological results, there is no connection between any disease, and I am not or providing any treatment of any disease. But these are very difficult to provide if these are the process. So any kind of patient, any kind of disease, any kind of terms like patient, disease, administration, or extracting the blood or urine sample. So these are the attractive terms in a claims which will attract this objection in the first examination report. Section 3J says that you cannot file a patent for any part, for any leaf, for any flower, or uh, for any plant. There cannot be any patent for a part of any animal or a plant, or the complete animal or any plant. No patent could be granted for that. But it is other than microorganisms. So seeds, varieties, essential biological processes, they cannot be granted. 3K, this is very particular, which comes for the inventions which are falling under computer inventions, or with the those kind of where we are using the programs. So there the 3K would come that it is only a mathematical method or any business method or algorithm. So algorithm, computer program, they are protected under the copyright. They are not protected under the patents. But if you are able to rewrite those things as a method of solving a technical problem or as a system for solving a technical problem, you are able to dig deeper into that technical real life problem and able to attach with every method step a hardware, how you are performing that method with this hardware. So by having that kind of set of claim, where you are having a method also, you are having a system also, and within the method when we are writing a process also, you are attaching the hardwares also with that. And in the specification you are explaining, describing. For example, you are solving a problem of the traffic jam by your computer program, by providing a system or by providing a program. So computer program as such would not be patentable. But if you are able to put that as a 5-step or 7-step method or the 3-step method, where you have certain steps only, and that steps are executed by a certain hardware. So with this set of claims, you are able to overcome this section 3. But this set of claims have to be drafted at the time of filing the application. You cannot change too much, or your amendments cannot go beyond a certain limit or beyond the scope of the originally filed at the time of replying to the objections. That drafting of the claims have to be at the time when you're filing the application. Otherwise, there are section 59 is also there, which restrict how much you can change your claim, how much wordings you can change. The scope of the original claims cannot go beyond that because most of the time when we receive the objections on the claims, then we say, okay, let us change the wordings then to solve the problem. But how much you can change, if you change if that change goes further beyond the scope of original claims, then a next objection would come that it is objected under section 59. That is, you can only change if there is any correction, if there is any typographical error, or if you are explaining something, it was present in the original claim and now you're explaining it further. So correction way is there, explanation is there, but the scope of the original claim is very much the boundary. 3L or the literary works, they cannot be patented. There is copyright for that. A mere scheme, a method of playing a game, or language, or method of learning a language, all this cannot be patented. But any system or any machine, if you able to come, that can be. This is for a method of doing that would not be patentable, but any machine or any system for doing that you can have the patent. Presentation of information, because with your idea, with your invention, you need to come up either with a product or a process or both. But if it is not final thing is not as a product, it is not come up as a process, then only an idea would not be patentable, or a presentation of the invention would not be patentable and objected under section 3N. Topography of the integrated circuits, they do not come under the patents, but there are different IP for the protection of these kind of inventions. 3 is for the traditional knowledge, which is there publicly known from many generations. So, and they are documented, even Unani, Sanskrit, and in the other languages also. These are documented, whatever used in a digital format, and it's available to the examiners with the patent office. And if they are TKDL documents, they will come up in the examination report that it seems to be the use or combination of these. There you have to distinguish. You have to provide the argument that my invention is different from these prior arts, from these general knowledge. Section 4 is very peculiar. It comes when there is an invention which is with respect to atomic energy, with respect to certain compounds of uranium, beryllium. So there is a different act, Atomic Energy Act is there, where we have the defined limit, defined amount, or the defined compounds which can be patented, which cannot be patentable, and in how much amount or in which combinations it will be patentable. Objections would come, but then you need to analyze whether the range is coming under the allowable range, whether combination is coming under the allowable. According to that, we need to file the reply. These are the additional things with the biotechnological. If the invention is relating to biotechnology, then you need to deposit the biological material. You need to submit the sequence listing in a searchable format, and you need to have the approval for the biological material if you are using from India. If you are not using biological material from India, then NBA approval will not be required. And you need to deposit the biological material also, and you need to mention those details. And if you are just isolating a natural source would not, and then it need to have some human intervention in working of the invention. Then only it will come from non-patentable category to the patentable category. Along, you need to mention the function of that, what you have isolated, what's the purpose of that, what's problem it would be solving. So NBA approval is also for the biotechnological, and if it's only synthetically prepared, or if it's a value-added product which is unrecognizable, physically inseparable form, then you have these arguments that you can file when it is objected. So these are certain kind of claims. So you see, first claim would be the broader one. So, is there any questions, or I can have some? Hello.
Yes, Preeti. Is the presentation done? Can we go ahead with questions?
Yes, yes, I can.
So any questions from the participants? I think this was a very comprehensive explanation of Section 3, which is very important as far as subject matter patentability is concerned. One of the core criteria for patenting. Okay. The audience don't have a question, but if I may take the liberty of asking a question.
Yes, yes.
There is one component which talks about business methods not being patentable, right? But in the Indian context today, there are several business methods. Like, for example, if I may say, let us say an HR professional comes up with a not really a business method, but some kind of a processing which enhances the quality of talent hunt. You know, let's say an inventor, an entrepreneur, an HR entrepreneur comes up with something like, where they're able to bring out some better results in terms of talent identification and all of that. So this need not necessarily be a business method, but can we call it a business process? And
See, it needs to be the final. If you're able for the system, because in these most of the exclusions, the apparatus of systems are more easy to be granted towards that. But if it's only a method, then you need to have uh, more arguments or more deeper things, because only a process for a talent hunt mayor, then you need to have what were the problems when we were doing in a conventional way, what we are solving for it, or if there were some automized methods available, because when the examiner would be doing the searching and he would be providing the examination report, certain citations would come. And mostly because the thing is that in India these are exclusions, but in US or Europe there are no such exclusions. So the citations would come from the US and EP. Indian examiner will pull out the US patents or the European patents or the patents of other countries. Look, here they are exclusions, so people do not file those patents because
yeah,
they would be very hard to grant. But if someone files it, citations would come there. So the level of that technical advancement should be up to that mark to cross the barrier of those citations also. Exclusion is a second thing. I mean, there are 2, 3 categories of the objections, but the level of novelty inventive step would be the up to the global mark.
yeah,
You pass that thing also argument, and then in section 3 would also come.
right.
So mainly the business method, they are the controller's view or the examiner's interpretation is up to some monetary. If you are having how to run a business in a profitable way, in that way they are more objectionable kind of inventions. But if you are not touching the level of economics there, then it may be easy to. I will not say easy, but may be possible.
Okay, okay. So instead of using these specific terminals like a method of something like a process of or a system of, these are better words.
These
Is
are
that
better
what you
words.
say? It
So yes, yes,
describes.
yes. So drafting those inventions where you feel that they are not very easy for grant, there are exclusions in section 3. their drafting is very much important.
Yes,
Because
yes.
once you receive the examination reports, then you are not able to change the picture, change the terms, change the wordings, then it won't be able to change. So that picture you have to set from the first picture itself when you are drafting, when you are filing.
Right, right. Sure, sure. And how is the semiconductor industry doing? I mean, we don't have we do have semiconductor as a sui generis system, but are there uh, more IP filed under the sui generis system, or are they being filed largely under patents? Because patents,
Patents, no, with the layout design. If
yeah,
it is with the layout design, it won't be patentable. It will come with the different IP work, with the registration of the circuit design. So it
right.
would not come directly under the patents.
Okay, but how is this overlap being taken care of? So the technology part of it is patented, is it, of the semiconductor?
See, if your invention is lying only on the design part, then it
Okay,
won't go. But
okay.
if it is with around it, then
Application.
somewhat system and process we could do that. But
Yeah,
only on the design part, then it would be very, very difficult because they have the certain different IP protection for that, not the patents.
right, right. Sure. Okay. These were my questions. Any questions from the
Yeah,
audience?
you can share with us, and we would be happy to reply those answers.
If not now, maybe they will come back with some questions as they go through a lot of content and literature. And we would also request you to please share your articles so that we will also be.
Okay.
And
Yes.
as far as the assignments are concerned, I think for this particular session, you have shared it with Dr. Anchal. So our participants will work on the assignments and they will revert back to you.
I actually shared the PPT in advance syllabus, but assignment I would share it in 2-3 days.
Have any assignment like an MCQ or just roundup of what we have
Yes,
learned
yes.
with us, and we will forward this to the participants as well.
Thank you. Thank you. And can we have just whoever have been the speakers, their email IDs? Can we have just
The speaker's email IDs, is it?
yes,
Uh,
yes.
but for today's session,
Yes, for today's sessions.
of course.
Just for connecting them with them and nothing more than
Yeah,
this.
sure. Yeah. We'll be happy to share. We'll be happy to
Yes.
share today. Actually, we had all the four instructors today are from Lixorbis only.
Okay. Okay. Then, then okay. With other organizations of
Yes.
those.
I'll be happy to share with you. Yes, we'll do that. We'll share all the details.
Thank you.
Thank you so much. Thank you, Ms. Preeti, and a wonderful session indeed.
Thank you for this opportunity. Thank you very much.
Thank you all.
Thank
So
you.
have a
Thank you.
all of you. The weekend is over, and but there was a lot of learning during the weekend, I'm sure. So
Yes,
lots
yes.
to take away over the weekend, and just keep working over these assignments and the videos. If you have not watched the videos previously, please go back and watch the video sessions. Read a few articles which have been shared with you. They are really interesting stuff. And maybe you can make some case notes, or you can just prepare yourselves on some important points of what you have learned out of the sessions. Next week we are going to come up with some things more insightful and interesting. So next week we are going to cover the other forms of intellectual property and their registration process, like trademarks, designs, copyrights, and geographical indications, plant variety. So we're going to cover a whole lot of the registration parts all of the next week as well. Again, mostly in the workshop mode, where you'll be able to have some hands-on experience from the instructors, from the professionals, of how these are being done, what are the difficulties they face, usually while in the registration process. So these are the 2 sessions lined up for the next week, that is on the 16th and 17th. So I look forward to meet you all then. Until then, happy learning. Take care of yourselves.
Thank you.
Thank you.
Thank you. Thank you so much.
Thank you. Thank you.
Bye.